The first case on the docket for Friday, February 4th, 2022 is appeal number 124395 in the matter of Daniel J. Martinez, original action and attorney discipline, no briefs filed. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please come to the lectern and state your appearances?
Justice Luker, members and justices, Kathleen Seltzer-Lippert, Deputy Disciplinary Administrator, on behalf of petitioner, present and ready for argument.
May it please the court. Mr. Martinez appears in person by John Ambrosio. We are ready to proceed.
Thank you to both counsel. Ms. Lippert, you may begin your argument.
I would request permission to reserve 3 minutes.
3 minutes is granted. Thank you.
The nature of the case in re Daniel Martinez is an original action involving attorney discipline after an evidentiary hearing. Briefly, there's 2 general categories of misconduct. One involves his personal conduct related to domestic battery, failure to timely comply with the court order, failure to file taxes for 7 years. The other category is his representation of a client facing serious criminal charges. His attorney retainer fee required or stated that the fee was earned upon receipt. The client was facing serious criminal charges, and with his criminal history, he was presumptive prison. However, the respondent promised him or assured him of probation. They advised his client to decline a plea offer of approximately half the prison time. The client did plead open as charged, and he filed a departure motion approximately on the eve of sentencing, which was included 100 pages of exhibits that were disorganized, and also provided the court with adverse information the court did not previously have. No exceptions were filed by the party. The only issue before the court today is sentencing. At the evidentiary hearing, the respondent requested an indefinite suspension stayed with probation and specific terms. My recommendation at the evidentiary hearing was 2 years suspension, followed by reinstatement with probation, and the panel's recommendation was 3 years suspension, stayed and placed on probation for 3 years, adopted all of the probation recommendations of the respondent, and the hearing panel also recommended return of $9,000 in attorney fees, comply with all recommendations contained in the evaluation report, and costs. My recommendation now, the respondent has returned practice monitor. Probation plan.
Yeah, Ms. Lippert, could you clarify what happened as a result of the plea that his client DT took? It's unclear to me exactly what the misrepresent or what occurred that it's unusual that a plea gets withdrawn and then a resentenced to nearly half of the time, and I assume it's as a result of Mr. Martinez's representation. So what happened there?
Advised his client to decline that. The client the court found that DT, the client, was prejudiced by the court noted the state agreed and then it was set aside. He entered the plea to the amended charges that had originally been offered and ultimately was sentenced to approximately half the sentence as the original plea offer.
Thank you.
Can you tell me a little bit more about the recommendations from the, was it Paramount Recovery evaluation?
Yeah, the Paramount Recovery included some recommendations for treatment, the diagnosis, and I will mispronounce the proposed diagnosis, but it involved several different issues and conditions related to a mild form, perhaps, of bipolar is one way to describe it, but did recommend some treatment, and he is involved with KLAP, and KLAP reports that he is compliant with all the recommendations, which would include the recommendations.
Counsel, are you satisfied that, based on the information that you have, the respondent is fully compliant with his proposed plan of probation?
Yes, the information that I have would indicate that. Particularly, I was concerned about, because he was behind on 7 years filing of tax returns. Those have now been filed. I believe he's on a payment plan. As long as he complies with that payment plan,
Lippert?
Madam Chief Justice, members of the court, may it please the court. There's no doubt in my mind, and there should be no doubt in anybody's mind, that my client mishandled a criminal case. He handled it badly and in less than stellar fashion. He admits that, and with your permission, after I finish, he would like to address the court. We came up with a probation plan that would turn him into a good practicing lawyer. A lawyer that keeps track of his time, which he never did before, and he is now. A lawyer that puts money in the trust account that is not earned and draws down as it is earned. A lawyer who has in his contract the contract that says It is earned not when you give it to me, but as I do the work, as I do the hours on this case. And he understands that. He has been working with his probation supervisor now for about 1.5 years. I believe that the supervisor's reports have shown that, number one, his files are in good order. Number two, that he's handling all clients' cases in appropriate fashion, that he's keeping track of his hours, and more importantly, that he's advising his clients. The mistake he made, and I don't understand open pleas. I never did as a criminal defense lawyer, but who am I to judge somebody else's work? An open plea doesn't make any sense at all. Obviously, the prosecutor, when he made the offer of the 66 months, wanted my client to convince his client to take that deal. And my client was less than stellar in explaining to his client what was going to happen if he went to trial, what was going to happen on an open plea. The evidence in this case is that there was a road rage incident. The evidence is that there was a child in the car with the criminal defendant. The evidence in the case is that my client's client brandished a firearm. No judge anywhere is going to allow somebody with a criminal record, unless I've misjudged all judges, out on the streets without doing jail time. And my client's obligation, and now he understands that, was to take the client into the office again and again and again and tell him what's going to happen if you don't listen to me. But he also needs to put it in writing. It needs to be in an email. And it needs to be in a letter. He was not practicing law that way, and now with the help of his supervisor, he is practicing law that way. During this, not to excuse his behavior, in addition to not filing taxes, he was in what I call a toxic marriage. And again, no excuse just because you're in a toxic marriage to put your hands on your spouse, be it man or woman. He was wrong about that. He was wrong about the way he dealt with his children. He's going through counseling. He took the courses that were required by the psychological report. He went through all of those courses, albeit with Zoom, which is not a pleasant way to do counseling because it's not close enough. It's not good enough. But he's done everything that's needed. All of his taxes are not paid, but all of his returns, with the exception of last year, obviously, are in already, and his accountant has filed both the business and individual tax returns. He now understands, because I've told him that every time you don't file a tax return, federal tax return, that is a federal misdemeanor. And if they catch you, lawyers in this state have gone to jail because of that. He understands that. He's working his program. He's working with KLAP. He has a monitor with KLAP who meets with him every couple of weeks to make sure he's doing okay. He's not on any special medication. And frankly, I had to do some research on this cyclothymic disorder. I had never heard about it before. It's very similar to bipolar. Although not all people are identified as having same, there's anxiety, there's some depression, and he's dealing with that through the courses. He's keeping track of client funds. He's writing down his time. He's trying to see his kids, although they're against seeing him at this point because maybe it's caused by his wife, maybe it's caused by his behavior, but he's working through that with individual counseling to try to get in that situation. He has done everything, and I think that's why my colleague and friend changed her recommendation from a 2-year suspension with a hearing before he's readmitted to letting him do this probation plan. It is working. The only problem I have with Mr. Leininger, who does a good job, and having done on 2 or 3 occasions supervise somebody's practice, we hate to send the reports in. No lawyer likes to send those reports in, but he sent in 4 reports, and I will talk to him after today about getting in a report every month to my colleague in the District Administrator's office. Unless you have any questions, I think it's very important that my client address all of you.
I have one question. The plan is that at the end of probation, there would be simply a report submitted that he has successfully completed probation, and that would be the end of it.
It wouldn't be the end, because I understand the rule of the court. We have to file an application with this court to say it's okay. We
Right.
can't, you're on probation forever, Your Honor. You know this, of course, until you let us off probation. And he will do
But
a
it wouldn't
report to their office, and then an affidavit that's required by his supervisor to the court, and then it's up to you whether or not he continues on probation or we go back like the rest of us and just practice law.
But it wouldn't require a hearing.
No, no hearing, no hearing. I'm sorry. I
No, that's-
misconstrued what you asked me. May I have my client address the court? Ask if once you get up here. Please.
I stand before you humbly, and I apologize for my actions. I prepared something, but I'm going to speak from the heart. I do apologize. I did handle Mr. Troutman's case in a less than unprofessional manner. I can go through the details, but I am a different person now. I deal with Mr. Ambrosio. He gets tired of dealing with me, but I do call him on a very regular basis. I respect him. He's very difficult with me on the things that need to be accomplished, but I know I need to do those to be a better person and a better attorney. It doesn't excuse anything I did with my home life. What I've learned is through counseling and just through the life that I lived, certain things I can't control. In the past, I would try to control things that were way out of my control. That is my problem. I've realized that now. I do the best I can with my kids. I do the best I can with my ex to try to communicate and raise my children. That doesn't excuse what happened with Mr. Troutman. But at the time, there was a lot of pressure, a lot of home life pressure to accomplish certain things, to try to keep the family together. And I just want an opportunity. I know I'm not a bad person. I'm a religious person. I go to services every weekend. I deal with people with respect. I deal with other colleagues with respect. I hope that shows through with the reports. I have friends in the profession. I love helping people. I really don't do this out of financial gain. I enjoy walking through people through the process. I've always had to struggle in my life to get to certain points, and I ask for an opportunity from the court. That's all I have.
Further, Mr. Ambrosio.
No, Your Honor.
Ms. Lippert, you reserve 3 minutes.
Unless the court has questions, I stand available. I have nothing further unless the court has.
Do I understand that once everything gets working, that your office is to receive monthly reports?
Yes. That is what I anticipate. I have received reports from the practice monitor October, November, and December of '21. I would anticipate I would soon receive a
Yeah, I mean, the point of going through this is that we get to a successful landing at the 3-year mark, and so that's going to require your office to participate. And maybe I should know the answer to this, but at the end of the 3 years to get off probation, does that come back to us through a recommendation on your office?
There's an affidavit, and then I would want to review the rule again before I state totally, but we would then report to the court our position on the probation.
Anything further? Thank you, Ms. Lippert. And thank you to all of you for your arguments and presentation this morning. With that, the court will take this matter under advisement.